Folks, there is trouble in paradise. Apparently, sometime in December, Karen Reed has leaked accidentally a certain email that was meant for her lawyers with her own personal thoughts. Turns out that email was leaked to the opposing party, John O'Keefe's lawyers. Oh yeah, let's talk about it. It doesn't say anything new. You must follow the law. He was present, so I think he can answer whether or not it happened or not.
Have you had any conversation with the prosecutor?
I could say the same thing by taking Amber Heard as a client.
Meant to, don't you think?
Oh, hardly.
Are you able to estimate of those 1,000 different types of cases dealing with accident reconstruction?
We're not with the jury present. That was a step.
Have you reached a verdict?
We, the jury, find the defendant not guilty.
Not guilty.
Not guilty.
Not guilty.
Not guilty.
Well, hello everybody, and welcome back to Buckle Up. It's the Law with Attorney Larry Forman. Folks, today we are going to be talking about the leaked email. Yes, I know, it just happened, and we have to talk about it. Folks, apparently, back in December, there was an email that Karen Reed, when she hit reply, she didn't realize she was accidentally hitting reply all to everyone in the string, including John O'Keefe's lawyers. Now, her lawyers are moving the court to strike, delete, and destroy whatever Karen has inadvertently sent. And they are arguing not only does it contradict her narrative, they're also saying this email stands and we're going to be able to use it for impeachment. So let's go over the documents, shall we? The first is the motion itself. Karen Reed's motion for order requiring plaintiff's counsel to destroy inadvertently produced communication. This is just the standard formality. And here's what she asks. Defendant Karen Reed respectfully requests that the court order plaintiffs to destroy all copies of an email that she inadvertently sent to plaintiff's counsel on December 16, 2025 by accidentally replying to all, quote unquote, in response to an email in which she was blind copied, which unintentionally included plaintiff's counsel on her otherwise privileged message, which directly related to her legal representation in this case. Basically, attorney-client privilege, strike it. They don't get a chance to enjoy her private thoughts because attorney-client privilege applies. Despite numerous requests, plaintiff's counsel refused to delete the email or even temporarily sequester the message while seeking the court's instructions. Therefore, Reed seeks an order requiring plaintiff's counsel to delete the message and any copies and recover and ensure deletion of any copies sent to his clients or anyone else. In support of this motion, Reed submits the accompanying memorandum of law, which we're going to go over. So basically, we asked nicely, delete it. They said no. Well, now we're coming to you, Judge. Defendant Karen Reed respectfully requests that the court order plaintiffs to destroy all copies of an email that Reed inadvertently sent to plaintiff's counsel. On December 16th, Reed accidentally replied all to an email on which she was blind copied, which unintentionally included plaintiff's counsel on her otherwise privileged message. The reply all email directly related to Reed's legal representation and this case, despite numerous requests that began 39 minutes. They started arguing, saying, like, can you delete it? Like 39 minutes after they realized the mistake. Plaintiff's counsel refused to delete the email, temporarily sequester the message, or even seek the court's instructions. They're basically like, oh, no, ours now, goodbye. Therefore, Reed seeks an order requiring plaintiffs to delete the message and any copies and recover and ensure deletion of any copies sent to his clients or anyone else. So here's the analysis. On December 16, 2025, Reed's undersigned counsel sent an email to plaintiff's counsel and blind copied Reed, so she would be aware of this email. Reed mistakenly replied all to the email to share her thoughts on the legal issue that was the subject of the message, which meant that plaintiff's counsel was inadvertently included on her response. 39 minutes later, another of Reed's attorneys replied all to Reed's email, informed all recipients, and particularly plaintiff's counsel, that the email had been inadvertently sent and instructed plaintiff's counsel to delete it without reviewing the message. Reed's counsel then followed up shortly thereafter, reiterating these instructions and requesting confirmation that plaintiffs had complied. Instead, plaintiff's counsel suggested, "I would not be doing that, sir." And despite the obvious context clues, he claimed that the email from Reed had appeared to be directed to him, and that somehow Reed's mistake, corrected minutes later, resulted in some undefined waiver of the attorney-client privilege. Reed's counsel followed up with plaintiff's counsel multiple times, explaining counsel's obligation under the applicable rules of professional conduct and case law, but to no avail. They don't care. We got it. It's ours now. We're going to use it. Plaintiff's counsel refused to delete the message, even sequester it, or seek the court's instruction. Although most cases regarding inadvertent disclosure involve an attorney accidentally producing in discovery a document that should have been withheld, Massachusetts courts have faced this issue before. Specifically in 2010, Judge Fabricant, that's a very fascinating judge for a situation like this, Judge Fabricant, decided that a client who replied all to an email to opposing counsel after being blind copied had not waived the attorney-client privilege. So that's good. They have case law on their side in Massachusetts. That's a Massachusetts Superior Court case from 2010. In that case, Judge Fabricant applied the standard that would apply in the more common scenario. A client does not lose the benefit of her attorney-client privilege for an otherwise privileged communication through inadvertent disclosure if the client proves that he and his counsel took reasonable steps to preserve the confidentiality of that particular communication. The court found that the client's transmission of the communication to opposing counsel was obviously unintended, much like this case, Your Honor. His mistake was of a type that is common and easy to make. Just reply all instead of reply. Literally, one button. They're right next to each other. Indeed, there may be few email users who have not on occasion used the reply all function in a manner they later regretted. Isn't that the truth? The court highlighted Michael Scott, comes to mind from The Office. Remember the Jan photo from Jamaica? Where he sends it to, I think it was packaging instead of packer or something like that. Yeah, that was... Have you been injured in an accident? Have you been hurt by a doctor? Have you suffered from a dog bite? Have you lost a loved one due to someone else's negligence? Call us, 1-844-774-HURT. Get a trial lawyer to get you the most money you deserve. The court highlighted the fact that counsel noticed the error quickly and immediately alerted the opponent and demanded deletion. The court also explained that, in that case, there were facts that supported a potential waiver, primarily that the same error had occurred before, and the disclosing party had not filed a motion to recover the email until much later when the opposing party attempted to use the email. But even with those countervailing facts in the matter, on balance, the court still explained that as a matter of courtesy and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosures. Are you listening, plaintiff's counsel? Lawyers, I'm going to read it again, should avoid the temptation. Ooh, the greasy little hands. They're acting like defendants, I swear. Normally, plaintiffs' lawyers are honest. They're like, okay, we'll pretend like it didn't happen. You know, they're like, no, mine. They're like Gollum. Hey, precious. Why? Why are you acting like this? Why are you so greasy? Come on, BB Fell, get your soldiers in order. Lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosures. It then held that, under the circumstances, the email in question was privileged and should be stricken from the record. Here, Reed sent the email in question at 2:28 p.m., and her counsel notified all recipients of the inadvertent message at 3:07. This is the first time the kind of issue like this has arisen in the case, and Reed is now serving this motion promptly after the message in question was sent. Thus, this is a clear case that charm warranting the same result of finding that the email is privileged. That's the case referenced earlier. Reed respectfully requests that the court order plaintiffs to delete the message and any copies thereof. Now, it's signed by Damon Seligson, and Rosenberg, and Waters, and it's dated January 9th, but it wasn't filed until literally just a couple of days ago. Here's their response. So the motion itself is like 3 pages, 2 pages, literally. Their response is a little bit longer. This is the plaintiffs. Let's see what they have to say and why they're saying it. So they oppose plaintiff's opposition to defendant's carried motion for order requiring plaintiff's counsel to destroy the inadvertently produced communication. They're saying, no, we get to keep it. Here's why. They respectfully submit this memorandum of law in opposition to defendant Karen Reed's motion for order requiring plaintiff's counsel to destroy the inadvertently produced communication and strenuously dispute the allegations set forth therein. Defendant Reed has presented no valid basis to claim impropriety on the part of plaintiff's counsel with respect to the contested email communication. By the way, to this day, we don't know what the email actually said. We don't have a copy of it. It's not available, obviously. They're trying to destroy it, the defense, for obvious reasons. The plaintiffs are like, no. They have it, but they haven't leaked it, thank God. Otherwise, it would be in deep doo-doo. They know not to. Nobody else has that communication other than Reed, her lawyers, and John O'Keefe's lawyers, presumably. Ms. Reed possesses the burden of proving that the email communication in question is protected by the attorney-client privilege and that such privilege was properly preserved. Plaintiffs contend that any applicable privilege was relinquished when Ms. Reed responded to opposing counsel because Reed and her team failed to adequately mitigate the clear and unavoidable risk of inadvertently disclosing confidential communications. Really? Really? That's the hill you want to die on? Oopsie is now they failed to adequately mitigate? Are you kidding me? Okay, all right, this is the hill they want to die on. In addition, even if privilege is deemed to apply, plaintiffs are entitled to retain and to utilize the email communication for impeachment purposes should Ms. Reed provide testimony inconsistent with her prior statements. So basically, we can use this in the future if we so choose. During a status conference on November 21st, 2025, the parties convened pursuant to Rule 9C at the direction of this court regarding plaintiff's contention that defendant Reed failed to provide a proper response to plaintiff's interrogatory number 1, seeking the factual basis supporting Reed's third-party culprit defense as required under the rules of discovery. On December 15th, 2025, plaintiffs filed a motion to compel further answers to interrogatories from defendant Reed, together with Reed's opposition and plaintiff's reply brief. That same day, plaintiff's counsel, remember we covered all of this on our channel. That same day, plaintiff's counsel served Reed's team of attorneys via email with the motion to compel Rule 9A filings, including plaintiff's reply brief. The following day, on December 16th, which is email day, 2025, Reed's counsel responded to plaintiff's email denying the allegations in plaintiff's reply brief and seeking immediate clarification regarding the statement that, quote, Reed and her team not only have leaked evidence and now appears inconsistent with the under oath answer signed by Ms. Reed, but also have stated publicly that she has evidence to suggest John O'Keefe was killed inside the house. Unbeknownst to plaintiffs, Reed's counsel apparently blind copied BCC'd, those of you who email on a regular basis, you know that function, Ms. Reed to the subject email chain before sending the response. Now, approximately 46 minutes later, Ms. Reed replied to all email participants with factual allegations that are relevant to the aforementioned motion to compel filings and the subject matter of the email chain. Plaintiff's counsel read the email response before recognizing that it may have been sent inadvertently and prior to receiving any notice from defense counsel regarding the same. The content of Ms. Reed's email response was inconsistent. This is what they're claiming. This is the big thing. Was inconsistent with her previous under oath positions in the interrogatory that is the subject of plaintiff's motion to compel. So basically what they're saying is she is contradicting herself with statements that she made under oath, and therefore we should be allowed to use it. It's a very interesting argument, again, especially because we don't know exactly what she said. Because theoretically, they could be massaging it to make it look like she is actually doing those things, when in reality, none of this is happening. And we can't even verify because we don't have the email. Because if we have the email, well, then everybody's going to know. And that's what the defense is trying to prevent from happening. Make sense so far? Okay, let's keep going. The next day, on December 17th, this court issued an order addressing the parties' discovery motions with a request that the parties attempt to narrow their areas of disagreement. With respect to plaintiff's motion to compel, court noted that Ms. Reed's counsel is requested to suggest to the court how to reconcile the position. There is nothing further for the court to compel, with the information in the 4th, 5th, 6th paragraphs on paper 58.1, page 2. On or about December 24th, Christmas Eve, at the request of defense counsel, plaintiffs agreed to hold their motion to compel in abeyance and to serve Reed with a supplemental interrogatory, rephrased to specifically articulate all facts forming the basis for affirmative defense number 2, to which Ms. Reed would respond as required by Superior Court Rule 30A. And the plaintiffs agreed to withdraw their motion to compel if Ms. Reed provides an acceptable response to the supplemental interrogatory. And the interrogatory is, state all facts forming the basis for your claim that plaintiff's damages arising from the death of John O'Keefe were caused by acts or omissions of third parties for whom Ms. Reed is not responsible, as set forth in affirmative defense number 2 in your answers to the plaintiff's complaint. And plaintiffs say they will happily provide the court with a copy of the subject email response for in-camera review at the court's request if they so choose, if the judge so chooses, which I imagine will probably happen. Here's their argument. Defendant Reed's implication that plaintiff's counsel has failed to fulfill their obligation under the applicable rules of professional conduct and case law with respect to Reed's email response has no merit. Plaintiff's counsel has not disseminated, leaked, or otherwise acted unethically in any way with respect to the subject email. Despite Ms. Reed's contention, plaintiff's counsel is under no obligation to destroy the communication at the direction of defense counsel or to affirmatively seek court intervention, whereas Ms. Reed has the burden of proving that the contents of her email response were privileged and that she neither intentionally nor unintentionally waived any such privilege at the time of her reply. Furthermore, even if this court finds that Ms. Reed did not waive any privilege, plaintiffs are permitted to retain and to use the subject communication to impeach Ms. Reed in the event that she provides under oath statements inconsistent with her statements in the email. So basically they're saying, look, we have it. We're going to use it. We're not going to leak it. We're not going to share it with anyone. But if she ever says anything that is inconsistent with this email that she has sent, well, then we have a right to impeach her in a deposition. Okay? Defendant Reed waived any privilege with respect to the subject matter of her email response. It's a very interesting argument, but let's see how they get there. In order to show that a communication is protected by the attorney-client privilege, the party attempting to assert that privilege must demonstrate: 1. The communications were received from a client during the course of the client's search for legal advice from the attorney in his or her capacity as such. 2. The communications were made in confidence. And 3. The privilege as to these communications has not been waived. Because the attorney-client privilege often deprives the court of relevant evidence, it is strictly construed. And it is the client's burden to establish its application to a particular communication. The existence of the privilege and the applicability of any exception to the privilege is a question of fact for a judge. Here, unlike the typical scenario involving an attorney's accidental production of confidential materials, which is the most common one. Remember the Alex Jones case where his attorney accidentally sent like literally all of the discovery to opposing party. To this day, I wonder if it was an accident or he just wanted to carve his own client out. Who knows? Well, we may never know. Ms. Reed herself chose to share her opinions on the legal issue that was the subject of the email chain when she responded to the group. Regardless of whether Ms. Reed's email response was inadvertent, this court should find that Ms. Reed waived privilege due to her failure to take reasonable precautions to prevent the disclosure of privileged communications. The SJC held that the modern trend has moved towards a principle that the privileged status of a communication or document is not lost when an attorney and client take reasonable precautions to ensure confidentiality, but, for example, a privileged communication is nonetheless overheard. In support of her motion, Karen Reed relies exclusively on the trial court decision in Charm, in which Judge Fabricant held that a client's accidental transmission of reply-all email communication to opposing counsel did not lose its privilege. While plaintiffs concede that the general circumstances in Charm are analogous to the present dispute, so they're saying like at Charm, Judge Fabricant in that case, in the Charm case, and Karen Reed in this case, very similar, almost identical. They're conceding that. But they're saying defendant Reed and her legal team conveniently disregard the clear message from the judge, warning future litigants of the preventable risk taken by Reed and her counsel here. In finding the question close, Judge Fabricant cautioned, quote, Kahn's counsel's practice of sending him a BCC of emails to opposing counsel with a CC to counsel gave rise to a foreseeable risk that Kahn would respond exactly as he did. In sending his response, Kahn would have to have known what he was responding to, but nevertheless, failure to take careful note of the list of addresses to which he directly directed his reply. On the other hand, a client who seeks to preserve the privilege has a responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Lawyers should advise clients to be careful and should avoid practices that exacerbate risks. Here, it appears that both Kahn and his counsel were less vigilant than they might have been. They and others should take note. Reply all is risky. So is blind carbon copy. Further carelessness may compel a finding of waiver. In that case, if that happened again, I'm just going to say it's been waived at this point. But this is a different case. Let's see what they have to argue. Here, the precautions taken by Reed and her team to ensure confidentiality of communications were careless. They were not reasonable. In all likelihood, by her own direction and or by recommendation of counsel, Ms. Reed has been blind copied to all email communications with opposing counsel since the outset of the lawsuit. Well, you can't know that. You can't prove that. You can't write that. Why would you write that? You're going to assume facts, not in evidence? Come on, you're a lawyer. You know better than this. As cautioned by Judge Fabricant, this practice exacerbated the known and obvious risk of broadcasting privileged communications to opposing counsel. Plaintiffs do not suggest that Ms. Reed should be kept in the dark concerning developments in the case. However, the foreseeable risk which occurred here could have been easily avoided. For example, when a lawyer includes the client on emails with opposing counsel, the client replies to all and the other counsel sees the message. An argument could be made that the privilege is now waived for all purposes. the plaintiffs argue. Under the circumstances here, including but not limited to Judge Fabricant's warning to future litigants, this court should find that Ms. Reed waived any privilege with respect to the subject matter of her December 16, 2025 email communications. Part B. Even if Ms. Reed did not waive privilege, plaintiffs are entitled to use the subject email for impeachment purposes. Even if this court determines, so let's say the court says, yes, it is privileged, yes, it is attorney-client confidentiality, yes, it must be stricken, we can still use it if in case of impeachment. Even if the court determines that Ms. Reed's email communication was inadvertent and that she took such precautions sufficient to preserve the privilege, the plaintiffs are entitled to retain and to use the subject communication to impeach Ms. Reed in the event that she testifies or answers under oath inconsistent with her statements in the email. In VigorWorks versus Skanska, the court held that while a party's inadvertent disclosure of a privileged communication did not amount to a waiver under the circumstances, such finding did not preclude the use of the communication by opposing counsel in the future to assess credibility. Judge Kaplan reasoned that the issue is a little like a bell that cannot be unrung, like with a jury, for example. No witness ought to testify in a matter that is inconsistent with the information communicated in the email. As with statements suppressed because they were obtained in violation of the defendant's constitutional rights, they may still be used to assess the defendant's credibility if he testifies at trial in contradiction of those suppressed statements. Similarly, in O'Brien, the court held that an inadvertently disclosed privileged letter could still be used for impeachment purposes under certain conditions. Judge Gantz notes that while this court has found that the inadvertent disclosure by Mira's attorney did not waive Mira's attorney-client privilege, it did not intend by this ruling to require O'Brien's attorney to sit quietly if Curtin or some other authorized representative of Mira were to testify falsely at trial. Judge Gantz further stated to permit the trial judge to resolve this controversy promptly and accurately, this court shall permit O'Brien's attorney to retain the privileged letter that was inadvertently disclosed as long as access is limited only to those attorneys who have already read it. This court shall also permit Curtin to be deposed concerning the purpose and meaning of the privileged letter, provided that this portion of the deposition shall be closed to all but the necessary attorneys and the portion of the transcripts shall be sealed. Here, Ms. Reed's choice to respond to an entire email chain and to make factual assertions directly relevant to disputed issues in the case, whether inadvertent or not, argue the plaintiffs, is a bell that cannot be unrung. Consistent with the above rulings, the plaintiffs should be permitted to retain Reed's subject email communications for use at trial and to further to depose Ms. Reed concerning the purpose and meaning of the subject email communications with any such conditions as the court deems necessary. Wherefore, for the foregoing reasons, the plaintiffs respectfully request that Reed's motion be denied. Plaintiffs further request that this honorable court find that defendant Reed waived her privilege, permit plaintiffs to retain a copy, and to use it for trial to depose her concerning the purpose and meaning of the subject email communications with any such conditions that the court deems necessary. And they are also asking for a hearing on this matter. And this is the email from Damon Seligson over to Mark Diller, and they carbon copied all the other lawyers in the case. Mark, in your reply brief filed with the court, you state that in doing so, Reed and her team not only have leaked evidence that now appears inconsistent with the under oath answer signed by Ms. Reed, but also have stated publicly that she has evidence to suggest John O'Keefe was killed inside the house. We deny having quote-unquote leaked evidence. Please identify your Rule 11 bases for making this claim, as we think this needs to be cleared up immediately. That was sent December 16th at 2:17 p.m. by Damon Seligson, and this is attached as an exhibit to the motion. What a crazy situation. Crazy situation. Definitely one that everybody wants to avoid if possible. Except the plaintiffs. I guess the plaintiffs are having a field day because they think they got their hands on something juicy. I don't know. I don't know how juicy it actually is. We don't know what it is. We may never find out. And now here's the reply by Damon Seligson and the team to the motion in opposition that we just read. Plaintiff's opposition relies on alleged practices by Reed's counsel, which plaintiffs make up out of a whole cloth. Literally, what I said, that is, you can't just assume, oh, we do this on a regular basis. You don't have no idea whether we do or not. They then argue that these non-existent practices resulted in a waiver of perhaps the most important privilege recognized by Massachusetts law. I agree. The attorney-client privilege. Plaintiffs do so in a cynical attempt to abuse the party's honest mistake to seek an illusory litigation advantage. And this specious tactic should not be condoned. I love the language. Plaintiff's alternative argument that they should somehow be allowed to keep the defendant's inadvertently produced non-waived attorney-client privilege communication for impeachment purposes is equally baseless. On February 2nd, 2026, just a week ago, Reed served her answer to the second interrogatory, and even a cursory comparison of the two documents. The answer and the privilege communication demonstrates that the privilege communication does not provide plaintiffs any additional areas for impeachment. So basically, get off your high horse. There's nothing there. You're making stuff up. You're trying to, because we can't share the email, you can make it look like you have something when in reality you have nothing. I swear, these plaintiffs are acting like defendants. Normally, it's the defendants who are kind of sneaky snake oil salesmen. The defense is like being honest here. They're like, yo, bro, what are you doing? Stop it. And they're just like, we get to use it. We get to use it. Like, why are you like this? Idiots. BB, get your soldiers in order. You're supposed to be top dog over there. They hired you for a reason. Plaintiff's assertions are meritless, and the court should reject them. Reed's email resulted from an accidental reply all, the one time her counsel blind carbon copied her on an email, which does not come close to meeting the standard for waiver. Plaintiffs base their entire waiver argument on the allegation that, quote, by her own direction and or recommendation of counsel, Ms. Reed has been blind carbon copied on all email communications with opposing counsel since the outset of this lawsuit. Literally, what I was talking about. Like, how can you assume facts not in evidence? You're a lawyer, for God's sake. Factually, this is simply false, and nothing in the record supports it. In fact, Reed attaches to this reply an affidavit from Reed's counsel confirming, and then we're going to go over that in a second, confirming that this was a one-time blind copy to Reed and that it was not in his practice to include her on emails. However, even without this affidavit, there is nothing in the record that allows plaintiffs to make this unsupported, logical leap regarding counsel's practice, nor do they point to anything in support. They are making it up. Instead of seeking to capitalize on a common and understandable human error, which most lawyers, professionals, and other email users have committed at one time or another, plaintiffs and their counsel should heed Judge Fabricant's advice, which they conveniently replaced with ellipses in their opposition. As a matter of courtesy and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosures. The inadvertently disclosed privileged communication provides plaintiffs no unique areas for impeachment. Reed recently served her answer to plaintiff's second interrogatory, which seeks the basis for her affirmative defense that third parties caused Mr. O'Keefe's death. The answer is attached as Exhibit 1. Comparing this answer to the privileged communication demonstrates that there are no areas for impeachment unique to the privileged communication. Said differently, if plaintiffs intend to impeach Reed later, they can simply use the sworn answer. They don't need the privileged communication because there is no contradiction and there is nothing of value for you guys to use anyway. To be clear, Reed has no problem with plaintiffs asking her about any of these topics. She only opposes their attempt to use sharp practice to strip her of her benefit of attorney-client privilege. Attached is the interrogatory. Oh, we have the interrogatory. Oh, let's go over it. Okay, so attached here is the interrogatory, which is interrogatory number 2. State all the facts forming the basis of your claim that plaintiff's damages arising from the death of John O'Keefe were caused by acts or omissions of third parties for whom Ms. Reed is not responsible, is set forth in affirmative defense number 2. And here's the answer. Ms. Reed objects to this interrogatory to the extent that it seeks information outside of her knowledge and possession. Ms. Reed further objects to this interrogatory to the extent it seeks information subject to the attorney-client privilege or work product doctrine. Ms. Reed also objects to this interrogatory as premature because discovery is just beginning in this case, and she has not yet received full production from the Massachusetts State Police or Norfolk District Attorney's Office, among others, which may contain additional evidence or information relevant to her answer. Therefore, Ms. Reed reserves the right to amend or supplement this answer as discovery proceeds. Subject to and without waiving these objections, Ms. Reed states, I was acquitted by a jury twice of all criminal charges relating to the death of John O'Keefe III after a full and public trial that exposed pervasive investigative misconduct and corruption. I did not cause and am not responsible for Mr. O'Keefe's death. I did not strike Mr. O'Keefe with my car. Mr. O'Keefe's wounds are inconsistent with being hit by a vehicle and consistent with being in a physical altercation and attacked by a dog. The credible evidence indicates that he was beaten inside the home at 34 Fairview Road in Canton, Massachusetts, on the night of January 28th to 29th, 2022, and died as a result. Below, I describe certain information and facts of which I am currently aware. However, I believe there are additional facts and additional evidence that I do not possess, which will further support the referenced affirmative defense. To date, I've not engaged experts for a trial in this matter, and therefore this response does not take into consideration their opinions. Additionally, at trial, I will rely on my attorneys and experts to explain the evidence, what it means, and how it indicates who is responsible for Mr. O'Keefe's death. Other than knowing I did not hit John with my vehicle, and that it was not me who killed Mr. O'Keefe, I am presenting my knowledge solely as a layperson who observed evidence obtained and presented in connection with the 2 criminal trials against me. During my criminal trials, multiple witnesses provided testimony supporting this affirmative defense. First, my counsel engaged a private investigator who took photographs of a cement-rigged curb just inside the garage. And the pathology expert my counsel engaged opined that Mr. O'Keefe's head wound came from a ridged ledge. Further, 3 separate doctors testified over the course of 2 criminal trials that Mr. O'Keefe's arm wounds were consistent with an animal attack. And my understanding is that the owners of the house at 34 Fairview Road in Canton, Brian and Nicole Albert, testified in the first criminal trial that the Alberts' dog Chloe never went out into the front yard. Therefore, I believe Mr. O'Keefe was inside with Chloe. Next, Ian Whiffen, the Commonwealth's own witness, confirmed Mr. O'Keefe's Apple Health data showing 3 flights of stairs were climbed after 12:20 a.m. The Apple Health data also shows Mr. O'Keefe taking steps, enough steps to get inside the house at 34 Fairview Road in Canton. Mr. Whiffen further presented evidence that Mr. O'Keefe's phone battery temperature stayed flat for 3 hours in the middle of the night at just under 50 degrees, which is too warm to have been outside in the snow, and then plummeted just before I found his body at 6 a.m. Therefore, the evidence supports the conclusion that Mr. O'Keefe was indoors before 6 a.m. I also understand that a stain on Mr. O'Keefe's sneaker had DNA from 5 male contributors. I understand that there were 5 males inside 34 Fairview Road in the early morning hours of January 29, 2022, and that no one saw Mr. O'Keefe outside before 6 a.m., including Lucky Laughran, a snowplow driver in the area during the relevant time period. In addition to these facts, the individuals inside the house at 34 Fairview Road in the early morning of January 29, 2022, also took action that strongly suggests wrongdoing, including tampering with, destroying, fabricating, and manipulating evidence, all in concerted effort to direct blame towards me. At the same time, the individuals and entities who had the responsibility to fully investigate the circumstances of Mr. O'Keefe's death, including MSP, Canton PD, Norfolk DA's office, and the respective officers, troopers, and employees, all failed to adhere to their duties and instead ignored, destroyed, and failed to gather or investigate highly relevant evidence in and around the house after Mr. O'Keefe's body was discovered. They did so because of, among other things, personal connections between lead MSP investigator Michael Proctor, former and disgraced, and individuals within that house. Proctor and other investigators' inherent bias, the occupant's connection to various local, state, and federal law enforcement agencies, and all of that caused me to be singled out, essentially. I mean, this is everything we already know, but now we have it in an interrogatory form in a response to a question. This is interrogatory number 2, sent by the O'Keefes, answered by Ms. Reed with the assistance of her attorneys. The individuals in the house that night engaged in a concerted effort to direct the investigators' attention away from themselves and towards me instead. Accordingly, based on the information and evidence available to me, I believe that one or more of the occupants of the house at 34 Fairview, Canton, during the early morning hours of January 29th, caused Mr. O'Keefe's death. However, as a result of the destruction and concealment of key evidence, the truth about what happened to Mr. O'Keefe has been deliberately obscured, and I do not know which specific individual or individuals within the house fatally wounded Mr. O'Keefe. What I do know, without any doubt, is that I played no part in causing, participating in, or contributing to his death in any way. Signed under the pains and penalty of perjury on February 1st, 2026, Karen Reed. So just a week ago. This is brand new stuff. Brand new stuff. And last but not least, we have the affidavit of her lawyer, Damon Seligson. Good old Damon. I, Damon Seligson, on my oath, do hereby attest and declare as follows. He's over 18, attorney licensed to practice law in Massachusetts, member of the Massachusetts Bar since 1996, in good faith, good standing. He's a shareholder of the law firm that he practices in. He's local counsel for Karen Reed. He provides this affidavit in support of Karen Reed's motion for order requiring plaintiff's counsel to destroy inadvertently produced communication, and in response to statements that are contained in plaintiff's opposition papers. That's what he has to say. On Tuesday, December 16, 2025, at 2:17 p.m., I sent an email to Mark Diller, counsel of record for the plaintiffs. In the email, I asked Mr. Diller to provide me with the basis for certain assertions that were included in the opposition. A copy of the email is attached here too as Exhibit A. Mark, in your reply brief filed with the court... Oh, we already gone over this one. We already gone over this one just a minute ago. This is the same exhibit. Okay, moving on. My email copies by CC certain of the lawyers who have appearances in this action and includes my client by BCC. As a general practice, I do not blind copy Ms. Reed on email exchanges. With counsel, I have reviewed my emails to Ms. Reed and I cannot find a single instance other than this one time that I BCC'd her on the communications with other counsel, which would lead to the explanation as to why Ms. Reed accidentally hit reply all without realizing, because it doesn't happen normally. It doesn't happen normally. This was the one instance. That's starting to make sense. Instead, with any communication from and among counsel that I shared with Ms. Reed, it is my practice to forward those exchanges to her by a separate email. The fact that I BCC'd Ms. Reed on my December 16th email to Mr. Diller was a one-time event. And by the way, that is supported by the record, because the one time he does that, she accidentally screws things up and replies all, because she's used to replying all and it always goes to her lawyers. Now she replies all and it's like, oh shoot, I just sent it to everybody. Using her cell phone at 2:28 p.m., Ms. Reed replied to the email but inadvertently replied to all recipients. Realizing that Ms. Reed's reply email had been sent to all and that replying to all was inadvertent, my law partner, Aaron Rosenberg, immediately communicated with Mr. Diller by email at 3:07 p.m., so 39 minutes later, explaining that our client reply to all was inadvertent, and in his email, Mr. Rosenberg requested it be deleted without review pursuant to the Massachusetts Rules of Professional Conduct. And that's Exhibit B. Let's take a look real quick. Mark, Dan, Jason. This email was sent inadvertently. Please delete it without reviewing pursuant to the Massachusetts Rules of Professional Conduct. That's it. Nothing fancy. At 3:51 p.m., I sent a follow-up email to Mr. Diller reiterating that the reply from Ms. Reed was inadvertent, and I expressly requested 1, that he and his legal team refrain from reviewing or disseminating the email or any attachments. 2, that he and his legal team delete the email and all attachments from his system and any backups. 3, that he confirm in writing that no portion of the email or attachments has been read, copied, saved, downloaded, or otherwise retained. And 4, that he confirmed deletion of all such materials and any derivative copies. A copy of the email is attached here too. So here's the email. Dear Mark, following up on Aaron's request below, the email he refers to was inadvertently sent to you from my client with the subject reply brief at 3:02:47 p.m. Eastern Standard Time. It was not intended for your review. The email and any attachments thereto are privileged and confidential attorney-client work product materials. Pursuant to your ethical obligations under the applicable rules of professional conduct, you are hereby formally notified of the inadvertent transmission. You are directed to immediately, here they are, 1, 2, 3, and 4 that we just went over. We don't need to go over them again. You can see them on your screen if you need to pause the video. We appreciate your prompt attention to this matter and request written confirmation of compliance at your earliest convenience. Thanks, Damon. And last but not least, Damon wrote, Mr. Diller refused. And accordingly, we served the plaintiffs with Ms. Reed's motion, and this was signed just a few days ago on the 4th of February. Wow, what a mess. What a giant mess. What a cluster. Unbelievable. I obviously, you guys know I'm biased. I don't need to say that out loud. So I'm going to, maybe not bend over backwards to try and support what Karen Reed's lawyers are doing, but I am going to be looking at it from their perspective. That is no secret. But what I can tell you with certainty, folks, is that this is one of those situations where absolutely this seems to be like an honest mistake, where everybody should have just been like, look, let's just forget about it, call it a day and move on. But because the plaintiff's attorneys have nothing, they have to manufacture something to make it look like they have something. They have to constantly work to create a case because they have no case. They know they have no case. They know they're probably going to lose. So in order to try and not lose fast, they're trying to kind of like say, okay, well, what she said is inconsistent with what she's possibly going to say. We want to use it for impeachment purposes in the future, and and it's all bullcrap. There is nothing there. Nothing. And they know it, and the defense knows it. But the plaintiff's lawyers, they're playing dirty. They're playing tricks. They're trying to pretend as if we have something. And it's very frustrating. It's very annoying. It's very unseemly. And now Seligson and Jackson and Rosenberg and the team have to deal with it. I keep saying, like, BB fell. BB fell out of the sky. You know what I'm saying? Her name really is BB fell. I think it's Barbara or something, but she goes by BB. BB fell out of the sky into their laps, you know, to represent the interests of the O'Keefe. She seems to be like the top dog there. And I'm shocked that she is not like slapping a couple of lawyers around saying, what are you doing? Stop it. This is not worth the fight. Just let it go. And instead, either she's on board or they didn't tell her. I don't know. I don't know what's going on in that camp. I thought they brought a heavy hitter for a reason. That's why I kept making these jokes throughout the video, like, BB, get your soldiers in order. Because she seems to be the most experienced of all the plaintiff's attorneys in the plaintiff camp, representing the O'Keefe's interests. This is just so bizarre and minuscule and irrelevant and unnecessary, distracting, and actually shows the weakness of the O'Keefe's position. Sun Tzu said, when you are weak, pretend that you are strong. And then when you're strong, pretend that you are weak to your enemy. They're doing the opposite. They are weak and they're showing their colors. Look at how weak we are. Why would you do that? What's the point? What are you gaining? You gain nothing, and you show your entire hand. You're holding a 2 and a 7. Congrats, you just showed how much of a losing poker hand you have. Why would you do that? A smarter move would be like to waive the issue. The fact that they're hanging on to like the thread of every hair, every strand of hair that they possibly can just to fabricate something out of nothing is depressing, folks. It really is. And I say that again, not as a biased observer now. I say that as a litigator. I say that as a trial attorney with nearly 55 jury trials under my own belt. I just won another one recently, and I don't know if I'm ever going to get a chance to post that one for you all, because the police officer was actually an undercover cop, and unfortunately, I may not get that tape for a while, but maybe one day. I don't know. I'm going to find out this week if I get a copy. Maybe I can get a copy with the promise that I don't disseminate it, which again is kind of pointless and meaningless, or they're just going to seal it, or maybe they're just going to give it to me and I'll have to wait until that particular officer is done with his undercover duties. But anyway, I digress. What I'm trying to tell you is I win cases. I know how to win cases. I know how to influence juries. I've done it dozens of times. And seeing this kind of behavior from a plaintiff's attorney, it's just unseemly. It's just so unseemly. They are not supposed to behave this way. Usually the plaintiff is the one that has the upper hand. They have the power. When they know that they don't have it, then, well, they're showing their hand and how weak their position is. And it's, like I said, it's very, very depressing that they have to stoop so low just to pretend like they have something. But what are you going to do? We just went over the filings, so you guys know what it is now. I hope you all learned something. As always, I love every single one of you. Don't forget to like this video, comment, subscribe to the channel, and I'll see you all in the next video. Bye, everybody.